It's a DWI. We just need to get medical records released. They're going to file the motion. I just wanted to approach to see if we can make note of it. It can be done in the meantime instead of when we come back for that release.
You mean
There's
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it. I'll sign it. As soon as you file it, I'll sign it. So it's old though. It's 184 days old. Do you have an offer?
we're supposed to be trying to get PTI on it. She did a TRAS the last.
So first apply. Don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So,
She's already done the TRAS.
oh, she's already done it.
Yeah, I had her do it when she was here last time because her appearance had been waived. So
Tell me, is blood test?
it should be blood from, it was a hospital visit. So yeah, there was blood. It was like a point one.
What is it? What are the results?
7, I believe.
Adults.
It's a point 1
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, so it's not.
Right here, they're talking about releasing medical records. This usually means they're preparing evidence either to support the defense or negotiate a plea deal. But notice how casually this is mentioned. Medical records can make or break a DWI case. Viewers, do you think medical privacy should be secondary in court cases like this?
I did have mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident.
Accident.
She ran into the back of a tow vehicle,
I think
but still an accident.
still gonna need it.
Right.
Because, they're gonna want insurance and all that stuff.
All right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need.
So
Okay.
what I would, so can you get the records to her today? Please file the motion. I'll sign it now.
Important legal moment. The judge is willing to let the defendant drive again, but only if she has liability insurance. This shows how courts balance public safety with giving defendants a chance to live normally. What do you think holds someone facing a DWI still be allowed to drive if they have insurance?
Now that way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response, whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. And can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay
Dad
with
told
it.
me he
As long
put
as
her
her
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? Sorry. Can you confirm with her now? Does she have insurance now?
Dad replaced her on. I confirmed with him. He was here last setting with her, and they were ready to confirm it then.
So they have car insurance?
It's not. Let me find out if he actually, because I told him that last time. Judge is going to want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay.
Yeah. And then after that, if she does, let Felicia know, and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk about it if you want to.
No, I get it.
Yes, sir. And we can show you from the years, if you would like, we can take you right through that second.
I don't think, look, have you seen what he's talking about?
Yes, and I just spoke with,
And is it as in the motion, as they say, have you seen this?
That is a transcript.
the
Okay.
facts of the motion are as also sentence. Yes.
What do you think?
I actually just spoke to Alex and he said that case was recently overruled by
It's just that the Erdman case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No, this is Serrano.
They cited the Erdman case, the underlying.
You talking about Simon? It didn't overrule Erdman.
They state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a Court of Appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Finan.
I'm sorry?
Finan is out of the Court of Criminal Appeals.
Okay, so tell me what it's, let's hear this.
1 second. So. One.
Obviously, we'll give you time to look at it so you can.
Yeah, no, it's still up to you. I've read Simon.
And I would like to share it with you. So it says the rules developed by Erdman's progeny are contrary to the fundamental rules to determine whether consent was rendered voluntary. Importantly, these rules, like the analysis of Erdman himself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances.
That's
And,
what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control a voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that. Good law.
So, and I want to give you time to look at everything, right? But I mean, this is like right on point with this.
100%.
Right on point, right? So
And
if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's,
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home. And
okay,
that's what
so
was said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? Yeah, we need to get up there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Consider ways and try to see which out on that.
Yeah. Yeah, as long you can confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Steven Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, AM. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Diana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Steven Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof.
Now, the defense is arguing that the officer gave misleading promise, basically telling the defendant, "Take the breath test and I'll take you home." If proven true, this could make the breath test evidence invalid due to coercion. This is huge. Did the officer influence consent, or was it a misunderstanding? Let me know what you think.
You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen.